Now I can see it. This court is therefore in total agreement with the submissions by the defense that a court's impartiality must never be open to reasonable doubt. For its moral authority without it would cease to enjoy legitimate public confidence and ready compliance with its decisions by all, and that our courts are to defend and uphold the Constitution and the rights entrenched therein. More so when the deprivation of an individual's liberty or freedom may be affected. It is indeed a core right to be enjoyed by all. Paragraphs 28, 29, 30, 31 and 32 sets out all the examples of sentences imposed by our courts as stipulated in the heads of arguments. There is no need to repeat the paragraphs, it was read into the record. What is clear is that there are a variety of sentences imposed by our courts regarding the possession of firearms over the years, pertaining to semi-automatic rifles, pistols, revolvers, including offences that were committed using firearms. What is to be distinguished in these matters are notably, as raised by the defence and as per the pre-sentence report and viva voce evidence of Ms. Thompson, the circumstances under which the offences were committed, including the purpose, therefore, thereof, the duration, and as highlighted by the defence, the issue whether any harm or injuries emanated from the offences. Further, that the ammunition was fired had been described as celebratory shots, and that there is no case law pertaining to the facts relating to the matter before court, more so based on the term used being, and I quote, celebratory shots. A further submission by the defence on record mentions that should any court consider a custodial sentence as appropriate in the matter before the court, it will be seen as the accused is singled out for unduly harsh punishment. The defence concedes the offences are serious and that the case law differs as the defence had pointed out in the case law on record, and surely again emphasised that the duration, circumstances, including the lack of harm to person or property, should be considered, that indeed it is the accused's right not to show any remorse. It has no impact on sentence. Further, that the accused regrets the perception that his actions created. When dealing with the pre-sentence report, it may appear as if it is a repetition on the side of the court, but I need to mention, because the points raised by Ms. Thompson indeed overlaps with the heads of the defence drafted on behalf of the accused. 51 of 1977, the court orders that the sentence... In addition to the heads, I will add the following. That the accused person's personality type was assessed, and the reason for doing so was to offer context to his conduct and potential behaviour expectations. Ms. Thompson had regard to the person... You may be seated, thank you.
I have instruction to proceed with an application for leave to appeal in terms of section 3091 and 309B.
May we, Advocate Oro, sorry not to interrupt you, may we just deal with the section 103 inquiry and then we can proceed to that part? I assume you are ready for that part as soon as we've dealt with the 103 inquiry.
Yes, Your Worship, and for bail pending the outcome of the appeal.
Certainly. Okay. Let me just find my notes here. Just as a brief explanation to unless it's not clear, the next step of this sentence is that the court is obliged to deal with the provisions of section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances. And the inquiry in terms of Section 103(1) Act 60 of 2000, since in terms of Section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of the crime
circumstances of
specified
the
in Section
accused,
103,
his
subsection
background,
1
education and career.
of Act 60
Further,
of
that the
2000,
accused continues to
and
assert his
reasons may
innocence.
therefore be advanced.
Nevertheless, however, he regrets the incident. The report deals with the evaluation of actual and potential harm because of the offences, the seriousness of the offences, as well as, once again, the purpose of the offences. And in recommendations, Ms. Thompson proposed that a monetary fine as a sentence option should be applicable, and describes the fine as a sentence option which will reflect the gravity of the offence. Further suggestions by Ms. Thompson were to restrict the accused person from obtaining a firearm license for a specified period, and that he should be ordered to